Good afternoon. Welcome to Monday's live stream with one of your deal doctors. Welcome. First, we're going to talk today a little bit about surprises that buyers get when they move into a house after they take possession. But before I do that, I want to just share a little bit of information about the answers and the information that we give to you as Eric and I and Kim, Paul and Greg. We speak for Greg when we give you answers, and we very often turn to other resources like our corporate attorney, Gail Anderson, and our E&O litigator, Pat Drucke, to give you the right information. The combined experience of the people that I mentioned, the five of us, is well over 100 years, probably closer to 150 years of real estate experience, and probably more than 5,000 transactions. I haven't counted, but it's a lot. So we don't take your questions lightly or just give you an answer off the top of our heads. It's something that we've encountered before, or we've gotten legal opinion on it to share with you. So, one of the questions, or I should say many of the questions, about a third to a half, I would guess, and I haven't done a survey on it, but those questions relate to when a buyer takes possession of the house and they get a surprise, a bad surprise. It's a surprise nobody wants. They fall into, in most cases, one of three categories. The most frequent category is something to do with water. Water in the basement, leaky roof, mold. Those are all water-related problems. The second one is possessions. Either they've left possessions, debris in the property when the buyer takes possession, or they have removed property that the buyer thought they were supposed to leave, or the contract called for them to leave. So, and then the third one is what I call critters. Critters, we had one over the weekend or late last week that was about bats in the home, and that the buyer believed the owner knew about it. And what were the remedies? What was recourse? Well, because the seller didn't disclose it on the seller's disclosure form. The challenge that buyer would have in that particular case is, number one, they would have to prove that the seller knew about the bat problem and intentionally did not disclose it. What if the seller never knew about the problem, that it was something that a previous homeowner had experienced and had taken some measures were obvious that the seller had taken to fix the problem, sealing off certain areas. Maybe that was a prior owner who did that. So the burden of proof would lie on the buyer's shoulders to prove that the seller intentionally did not disclose. So that can be a hard burden of proof. But we've got critters, bats, ants, squirrels, raccoons, bees, all sorts of things that when buyers take over a property and move in, they may find out that their house is infested in some way. Again, what's their recourse? If they can't prove that the seller intentionally withheld that information, they probably have no recourse. So, I thought it was an interesting topic, and so Eric actually pulled up this article. It's called Legal Remedies If a Home Seller Lies or Conceals a Defect in Michigan. Let me repeat that. Legal remedies if a home seller lies or conceals a defect in Michigan. That is on a website called Nolo, Nolo, Nolo.com. And if you Google it, you can pull this article up and print it off for yourself. I think that's really important that you have these sorts of resources available at your fingertips when the questions come up. So what do? First of all, the very first step is buyers shouldn't rely on the seller's disclosure as the whole picture of the condition of the property. That's the first step. Sellers can only disclose what they know, and many sellers, homeowners, are not experts in electricity or building structure or roofing, heating, and so on. Therefore, the buyer has a responsibility to, as they say, buyer beware. The buyers must go out there and have inspections performed. That's the first step in identifying and determining whether or not there is a property defect. So, as the article says here, before trying to determine whether another party is responsible, the first thing you need to do is to take steps to fix it. This is important for two reasons. First, if you do not repair the problem, it'll get worse. And second, the repair should be made for your comfort and well-being. It also helps to identify from a legal standpoint, it is the duty to mitigate. You can't simply allow a problem that exists to continue to grow, or the courts will look at you and say, well, wait a minute, what did you do to stop this problem when you found out? So the other thing is that they have to have inspections. Buyers need to have inspections to help them identify potential defects. So a buyer is going to have to identify what their damages are as a result of a seller not disclosing something and then it appearing afterwards. Another good step here that they mention is to contact the homeowner's insurance. Sometimes it's covered under homeowners, not always. And particularly with water problems, probably not. So, but it's nevertheless a good idea. You may have a home warranty, or you may recommend a home warranty, and that may help to alleviate damages if those kinds of things occur. We've talked many times about setting up an escrow to assure a buyer that when they move in, that there's going to be a pool of money available if the house is left in bad condition, or if there are personal items taken that shouldn't have been taken, or if we discover there's a latent defect in the property or an undisclosed defect in the property. So sometimes a home warranty will help you. Again, I encourage you to read this article because it's really full of great ideas. When you get a home warranty, let's pretend that you have a buyer you're working with and you say, you know, there's some concerns here about, let's say, the age of the furnace. Don't really want to make them an issue on the purchase agreement because you want the house, but, you know, the furnace is, let's say, 20 years old, 25. We've had it inspected. It seems to be working fine, but it's 25 years old. How about we put a home warranty on that? How about the buyer pay for a home warranty or ask the seller to pay for it? In some cases, I know that agents have paid for it as a protection for their buyer. All of those are possibilities. Keep written records of any expenses that you incur, that the buyer incurs as a result of the surprise, whether it's water, roof, mold, critters, possessions. Every piece of information that you receive, every communication, you should put it in writing. If you have a telephone telephone call, put that call, recap that call in writing in an email, recommended email. It's a lot easier to store emails and pull them up later in a file than it is to copy a bunch of text messages. So when you're dealing with issues that may end up in court, email is preferred over text messages. Granted, text messages are a lot quicker, but you're going to have to, if it ends up in court, you're going to have to go back and copy and paste emails into a file so that our litigators, our E&O folks, have documentation. So, who is legally responsible for the property defect? Well, as it says here, depends on who failed. Did the seller fail? Did the broker or both brokers fail? Or did the inspection fail? Those are all possibilities. And in extreme cases, in big lawsuits, I can assure you they're going to name everybody. And they're going to name their own buyer broker, they're going to name 5-star, they're going to go after the inspector, they're going to go after the seller. So we want to do our very best to eliminate as many of these kinds of lawsuits as possible. Question, did the seller know about the problem and have a duty to disclose it to you? Prior to selling a house, a Michigan seller is required to inform the buyer of certain property conditions by way of a seller's disclosure form. Now, there are certain sellers who are exempt, as we've talked about many times. And I believe we have that list on our resource site, but it's easy to Google. I mean, search on Google. Just type in Michigan Seller's Disclosure Form exemptions, and it'll pull it up. It'll give you a list, and that includes divorce situations, generally anything that involves a court, foreclosures, bankruptcies, and so on. Never occupied new construction. If a builder built it and lived in it for 6 months, it doesn't count. The builder is required to fill out a seller's disclosure form. An estate is exempt in most cases. There are some cases where they're not exempt. So it's important that you, as the listing agent and as the buyer's agent, recognize, again, investors, landlords, flippers are not exempt from filling out a seller's disclosure form. Read the law. It's not in there. They are not exempt. So, did they have a responsibility to fill out the seller's, to disclose something in the seller's disclosure form? The most difficult part of asserting fraud or misrepresentation claim against the seller is proving that the seller knew that there was a defect and intentionally made a false representation. Yes, I'm stressing those words. You have to prove it, and that the seller intentionally made a false representation. It's not just about if they made an error. That's not going to win in court in most cases. I'm sorry. If there is an escrow involved, what is the time frame? If the buyer is satisfied when they move in, when does the seller get the funds returned? Penny, thank you. That's a great question. And the answer is, I don't know. because I'm not the one negotiating the escrow. It's between the buyer and seller, and between the two agents who are negotiating the terms of that escrow to establish how that's going to be released. In fact, I was on the phone with one of our agents as I was driving over here on exactly this issue about what do we put into an escrow agreement. Well, that's a negotiation that occurs between buyers and sellers, and there's no one answer to it. So, for example, I'll use the one that I was talking about on the phone, and the seller is going to pay for an electrical repair after the closing, and they're going to set aside funds in an escrow so that those repairs can be performed. So the question becomes, how do you structure that escrow account? Well, does the buyer have any right to have inspections performed before they release the money? I don't know. That's got to be, if they do, then it's going to be in the escrow agreement. If the seller is using a licensed contractor, does the buyer have any right to make sure that it was done correctly? What's the guarantee that it's being done by a licensed contractor? The money's being sent to a company that says electrician on it. Have we checked their license? I don't know. Those are all really good questions that you, the agents, must ask in order to establish that escrow agreement. So, in general, Penny, to address your question, if the buyer is satisfied when they move in, they could stipulate, they could agree, the two parties, that the money will be released upon the buyer's satisfaction, but not later than 5 days, 10 days, 60 days after possession has been delivered to the buyer. It's a matter of negotiation. If they're satisfied when the buyer moves in, the buyer's satisfied when they move in, they look around, they go, hey, yeah, that's great, no problem. They can put in the escrow agreement that they want the money to released right now, immediately. Or they can say, you know what, we'll release it within 30 days. We'll give it 30 days to make sure that there's no other problems that crop up. It's all a matter of negotiation. Hope that's a good answer for you. There's another, in addition to proving intent, there's also another thing that the law requires, and that is you must also prove that you relied on the seller's statements. So, let's pretend, and this happened, I'm not using this, I'm not making this up. Let's pretend that the buyer is a county drain commissioner, and the buyer knows all about where all of the sewer lines are in the county. The buyer buys a house and says, I want the seller to hook up to the sewer before before the closing. As it turns out, because of the geography and the water table and various other, and the size of the pipe leading out from the house toward the sewer, they can't without it being an extreme expense. So, the seller, on their own, decides that they're going to replace the septic system. And the buyer knew about it, the drain official knew about it before the closing. Well, the agent did. Buyer finds out about it on the day of closing and continues to close, regardless. It's only later that the buyer becomes upset and decides to sue. And yes, the buyer sued everybody. However, under this law, this clause in law, to establish fraud or misrepresentation, you must also prove that you relied on the seller's statements. Well, in this case, the buyer didn't. It was clear that he had information available to him that he could have researched, and probably did, and he was given different information prior to signing the documents at the closing. So ultimately, after thousands of dollars in legal fees and months and more months in court, Five Star was eventually released from the lawsuit. But it's a real kick in the teeth to your business to go through this. Did the broker know about the problem? Did the listing broker know about the problem and have a duty to disclose it to you? This is a question we get a lot. A seller's broker in Michigan has no legal obligation to disclose a property defect to the buyer and is not liable for the seller's misrepresentations about the property. There is still a possibility, however, that the broker may have some legal liability. If you can prove that the broker acted together with the seller to conceal or misrepresent the information, the broker could be legally liable for fraud or misrepresentation. Again, it requires proof. It requires the burden of proof is on the buyer. Let me caution you that if you're working with a seller who is not going to disclose a material defect and you know about it, I encourage you to walk away from the listing, because the likelihood is that when the buyer buys it, moves in, and experiences a problem with that material defect, they are going to turn their attention to you. The arrow is going to turn to the agent, the listing agent, as well as the seller. Be very, very careful if you go down that road. Should the home inspector have spotted the problem and brought it to your attention? Well, maybe. It's possible. You have to look at the inspection if that were to happen. Does the inspection call out that particular defect? Does it miss it completely? The most likely situation in winning such a claim against an inspector is if it can show negligence, that if that inspection or area should have been inspected, or there was something to cause the inspector to look further, more deeply, and the inspector chose not to, now you've got some teeth here. For example, if the inspector goes down the basement, sees a bunch of black spotting, shadowing on the wall, and doesn't say, maybe we've got a mildew or mold problem here, I think we need to look deeper. If that doesn't happen and it's not in the report, the buyer might have cause against the inspector. If you suspect, and this is really, really good advice, if you suspect that the seller concealed a property defect, or you find yourself in a situation where you need help, please consult an experienced local real estate lawyer. Now, again, if you call me or Eric or Kim or Paul or Greg, we are all going to give you the best advice we can based on prior situations that we have been involved in based on our years of experience. And if that's not enough, we're going to call our attorneys who are involved in this every single day to give you the best possible answers we can. Bottom line, if a buyer goes in and discovers something that they didn't expect when they get possession, the first thing they're going to have to do is try to mitigate it. Second thing they're going to need to do is to start adding up the potential damages. And damages could go beyond an actual court case. They may go years into the future. What does it do to the value of the property, for example, if you discover that you have a swimming pool in your basement every third Tuesday? It's going to have a significant impact. So, where would the Code of Ethics fit into this situation? Good question, Penny. You're full of them today. Thank you. Code of Ethics, Article 1 says that we must be have honest dealings with the public. And again, I think that is the reason, well, I know that's the reason, that I encourage I encourage people to say, you know, if you're not going to tell people that you have a swimming pool in your basement every third Tuesday, I don't want to be a part of this. You know, call another agent. Call one of those Coldwell Banker agents or Berkshire Hathaway. I wouldn't want to be a part of that listing who I know is intentionally misleading the public, because I could be perceived as being a party to that, and I could be sued, and I could be called up on a Code of Ethics violation for less than honest dealings with the public. Great question. Thanks, Penny. Any more questions before we sign off? I appreciate your attendance. How many do we have there today? Can't tell. How many do we have visiting with us today?
Right now we have 19.
19. Thank you, all of you 19, for listening. Next week, we're going to try to do something we've never done before. We're going to try have a special guest, Tim Creech, from our Jackson office, who is going to hopefully join us to help share some prospecting techniques. Tim is a great prospector, telephone prospector, and we're actually going to do a role play if we can work it out technologically. So hope you will join us then. That's a sneak preview of next week. Tell all your friends, and we will talk to you next Monday. Bye.